I love how Special Counsel Jack Smith is now basically mocking Donald Trump in these filings. Take a look at what Special Counsel Jack Smith just filed in reply to Donald Trump's opposition to the motion for premature jury questionnaire. And the Special Counsel Jack Smith's point when he filed a motion for a jury questionnaire was to basically tell Judge Eileen Cannon, look, Judge Cannon, in the Southern District of Florida, Mar-A-Lago document case, the Trump willful retention of this classified information. Judge Cannon, you claim that you want to have this trial May 20th of 2024. Okay, Cannon. Okay, Trump. Put up or shut up. We need to start getting the jury questionnaires ready because in these types of high profile, high publicity cases, this is what the district courts follow now in selecting a jury. So we've got to start this process if you really want to have a May 20th, 2024 trial. And we've been saying here on the MeidasTouch Network that we don't believe that Judge Cannon is serious about that trial date. And she wants to keep a May 20th, 2024 trial date just to try to block other trials taking place in that time period against Donald Trump. She's trying to protect Trump. So Special Counsel Jack Smith's like, okay, well, let's see if you're serious about this date. So Jack Smith filed a motion for jury questionnaire. Let's get the process started. And Jack Smith said, let's get the jury questionnaire process started by February 2nd. Jack Smith knew he was kind of baiting Donald Trump and testing Judge Cannon. So then Donald Trump filed in response an opposition. No, we should not do a jury questionnaire now. We should not get the process started. There's so much that could happen. Why would we actually go through normal steps to pick a jury? And then Donald Trump, in his opposition to the motion for premature jury questionnaire, in this opposition, Donald Trump asks Judge Cannon, can you please admonish the special counsel? Can you please yell at Jack Smith and tell Jack Smith to stop filing documents? Judge Cannon, we just want to go by basically we want to show up on a March 1, 2024 status conference, and that's about it. So just have Jack Smith stop sending us these documents. We really need to spend a lot of time just looking through discovery and having Jack Smith, ask for things about a normal procedure for a jury. That's just so burdensome right there. It's so burdensome. By the way, if you say, Ben, that can't be really what Donald Trump filed. Look, Donald Trump's opposition to motion for premature jury questionnaire. And then Donald Trump says the court should deny these efforts to set deadlines. And then Trump says, moreover, in addition to wasting the court's resources, this type of litigation detracts from defendant Donald Trump's efforts to review voluminous discovery and prepare motions that are crucial to the defense. Therefore, Donald Trump requests that the court order the prosecution to refrain from further motion practice outside of the existing schedule and actually compelling circumstances. I don't know. I think picking a jury in like a trial that's scheduled for May 2024 and doing the normal procedures, I don't know. That seems like a pretty compelling thing you would do if that's actually going to be the trial date. And then as you go through, if you go to page 4 of what Donald Trump's opposition to what Donald Trump calls the premature jury questionnaire, Donald Trump's, they whine. They go, for the second time in just over a month, Jack Smith, have ignored the court's scheduling order in an effort to impose deadlines with no reasonable basis. Trump respectfully submits that the court should put an end to the improper filings and admonish the special counsel that future abuses that interrupt the defendant's discovery review and defense preparations will not be tolerated. Look, if Donald Trump filed this anywhere other than before Judge Eileen Cannon, he'd not only be laughed out of court, he'd be sanctioned. There'd be some scathing order by a judge saying, excuse me, you think that it's so burdensome to have to review discovery in a case where you've been criminally indicted that you don't want to go through the process of scheduling the jury and setting the deadlines for a jury, and you want the court to admonish the prosecutors for saying, hey, are we going to pick a jury here pursuant to the normal procedures? So just watch how elegantly Special Counsel Jack Smith responds here in the government's reply in support of the motion for a written jury questionnaire. Here's what Jack Smith writes. He goes, defendants, Donald Trump and his co-defendants Waltine Nauta and Carlos de Oliveira, have filed in opposition to the government's motion for written jury questionnaire that is long on rhetoric and baseless accusations that do not merit a response. The government files this short reply to reiterate its reasons for filing the motion. The court denied defendants' motion for an adjournment of trial, and this court, you, Judge Eileen Cannon, maintained the May 20th, 2024 trial date subject to reconsideration at the March 1 scheduling conference. Accordingly, Special Counsel Jack Smith's basically saying, because you did this, Cannon, accordingly, the government has been working to ensure that it will be ready on May 20th. Among the pretrial events that even defendants appear to agree should occur in this high publicity case is the preparation and distribution of a jury questionnaire. When the government learned of the time necessary to send a questionnaire to prospective jurors, the government felt it prudent to bring the issue to the court and defendants' attention through the only appropriate channel available, a motion. In other words, Judge Cannon, this is a court. Just call up the judge or call up the clerk. This isn't how Donald Trump views court, where you post messages on social media. You have to file things called motions. And so we're just bringing to your attention, Judge Cannon, that as we've researched the procedures for how long it takes to send out jury questionnaires in the Southern District of Florida, the lead time, it usually takes about 10 weeks to do this. So we have to get started if we want that May 2024 trial date. Special Counsel Jack Smith goes on to say, defendants, Donald Trump and others, Nauta and de Oliveira, argue that the questionnaire could change depending on how the court rules on several motions they plan to file. But some of those variables, for example, anticipated length of trial and the trial date, are simple to amend, and other subjects the defendants suggest should impact the questionnaire are not even the proper subject of questions to the veneer, the jury pool, and in any event would form but a fraction of the questions the questionnaire would contain. More to the point, defendants' breathless castigation of the government for suggesting the parties engage on jury questionnaires before resolution of pretrial motions ignores that the same was true in cases the government cited in its motion. In one of these cases, for example, in Mentor, the court ordered that the parties submit a joint proposed questionnaire before pretrial motions, including for severance, disclosure, and suppression, were even filed, much less resolved. See, for example, the case United States versus Mentor, a case in the Southern District of Florida. In another case, Guraquega, the court similarly ordered the parties to submit joint proposed jury questionnaires before the pretrial motion deadline, United States versus Guraquega, Southern District of Florida, June 18, 2019. It is economical and good use of time to begin the process of drafting a questionnaire now. The Special Counsel Jack Smith saying, look, I understand these breathless castigations by Donald Trump and his lawyers, tilting at windmills and whining and complaining to Your Honor, but we're going to cite cases, okay? The government, we're going to follow the law. And if we look at cases in the Southern District of Florida, where other district court judges have done exactly what Donald Trump's lawyers claim does not take place in this district. But it does take place in this district. They could say it doesn't, but if we care about what the case law says, they are all submitted, these jury questionnaires, before even some of these pretrial motions are resolved. So, Judge, what in the world are we talking about here? And it says, for the foregoing reasons and those in the government's motion, the court should grant the requested relief, and it's signed by Special Counsel Jack Smith and the main lawyer working on this case, Jay Barat, and the full Special Counsel team. And again, it's just a perfect jab at Donald Trump. These breathless castigations. It's pointless to even reiterate some of the baseless accusations. And it's like, Judge Cannon, you want a May 20th, 2024 trial date? This is the steps. We'll see what Judge Cannon does, but if Judge Cannon does what I think she's going to do and say no jury questionnaire and reject this relief, because we're talking about Judge Cannon here, it plays right into Special Counsel Jack Smith's hand. Jack Smith wins either way at this. Either he gets the jury questionnaire, keeps the heat on Donald Trump, or Judge Cannon rejects it, and then Special Counsel Jack Smith goes to the D.C. Circuit Court of Appeals, maybe even the United States Supreme Court if direct appeal is accepted there, and the District of Columbia District Court, and basically says if there's any issues ever about the trial date happening, or any questions about when is trial going to take place in Washington, D.C., criminal case for Trump's attempt to overthrow the results of the 2020 election, and that's before Judge Tanya Chutkan versus the Southern District of Florida, federal case before Judge Eileen Cannon for Trump's willful retention of national defense information. Special Counsel Jack Smith can go, look, Judge Cannon hasn't set the CIPA Section 5 deadline yet, the key CIPA, Classified Information Procedure Act, deadline in a case like this. She hasn't sent out jury questionnaires. We know this May 20th, 2024 date isn't happening. Let's make sure that the case before Judge Tanya Chutkan, the federal criminal case in D.C., goes first, even if it's going to get kicked by 45 to 60 days from the current trial date, March 4th, 2024, because of the stay pending the expedited appeal before the D.C. Circuit Court of Appeals, or maybe even before if the Supreme Court accepts certiorari on a direct appeal. If it delays it 60 days, let's just make sure that this D.C. case goes first, because Cannon ain't serious about that May 20th, 2024 date. So that's where we're at. I love Special Counsel Jack Smith just mocking Trump at this point, just mocking. What are you talking about? So good. Keep you posted as we learn what the resolution here is from Judge Eileen Cannon. Hit subscribe. We're on our way to 2 million subscribers. Thanks to your support. Thank you so much for watching, and have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.